Driver causes serious injury to a member of the public, the driver is responsible to that injured person in an amount of money equal to the harms and losses caused. And remember also, it doesn't matter who was injured. It could have been anyone. It just happened to be the plaintiff. You may have heard me talk about car accidents before, and you may remember that those points I just made are actually the points we have to prove. I have to prove that there's negligence. That's unnecessary danger. The difference between doing things safely, and second safest choice is negligence. Negligence is defined in the law as a breach of a duty owed to a foreseeable plaintiff resulting in injury. In a car accident, that means that you failed to observe the rules of the road, or failed to observe just common sense and caused an accident. That can include maintaining your vehicle. The photographs I just passed out are property damage photographs from a bus accident case that we recently resolved this year. I may have mentioned it briefly before in this meeting, but not as a 10-minute. You'll see the total damage to the vehicle is to the rear view mirror, the driver's side rear view mirror. Side view mirror. And the glass isn't broken, the glass is just knocked out and hanging. People think that this is an injury case. Is this a good case? Anybody think that this is, are you ready to give money?
No.
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 Remember, we're bringing a lawsuit for money damages in Westchester County.
It looks pretty minor.
People, that's right, thank you, Scott. Thank you for saying what everybody else was thinking.
You're welcome.
Having the courage to stand in front of this group of people.
You're standing,
right,
I'm not.
You're right.
Put him under Jerry. Put him under Jerry.
Yeah.
So, a case like this, it's an uphill battle for the plaintiff to show that there is a serious injury. We have to show it's somebody else's fault also. In this case, the accident resulted from lack of maintenance, improper maintenance. Two buses were passing on a narrow road. My client was in a minibus. The defendant was driving a full-size coach bus. And one of the engine access doors on the coach bus was open. It popped open. One of the side doors. I don't know if it's engine or luggage, but it's a side door on the bus. Pops open when they're driving over a bump, and it stays open. All that hit the only thing that hit my client's vehicle was that side door. Hit the mirror and caused the mirror to close, the glass to fall out. But it was at night, it was a very narrow road, and she didn't know what happened. When the impact occurred, she lurched in her seat against her seatbelt to the right, away from the point of impact. So imagine a bus is driving by at night, very close by your vehicle, and suddenly there's a whack as it goes by. She lurches in her chair, breaks a rib against the armrest, tears a rotator cuff, and herniates C3-4, C4-5, abutting the cord. Right? This is a bad accident. Defense attorney, very shrewd, old Irish guy from Long Island, says, sorry.
Yeah, you're on camera.
He says, I got this. I got this, Duffy. His partner's name is Duffy also, so unfortunately. He says, I've got this. I don't care. It's a fraud. Your case is BS because I've got this. Now, who here has gone to the doctor and had the doctor ask to see the instrumentality of the injury? No? No one ever went to the doctor and you tripped, you broke your ankle maybe over a rock? Did the doctor ever want to see the rock? The doctor ever want to see the shoe? So if you're in a car accident, does the doctor need to see the car? No. Is it relevant to the injuries? No. So if the facts are against you, and sometimes the facts appear like they are against you, you argue the law. We made a motion in Supreme Westchester, and this is just the decision I'm handing out. It's not that fascinating. You can read it if you want. You can look at it. You can see the work that goes into these cases. But the point is that we made a motion in court and used the law to our advantage, and we had all the defenses to this case dismissed. So the defense attorney could no longer argue it wasn't our fault. The defense attorney could no longer argue that we didn't have a serious injury. The only things left for the jury to decide was how much.
So where's the statement?
So this is a case that this is the kind of case that many lawyers will see come into their office. And when they see the broken mirror, and that's all that happened to the vehicle, they say, this is not a very good case. And they'll take what's being offered, nuisance value. So the offer on this case was under $10,000 for several years, until we made our motion, I made our motion, and we got I didn't tell you yet. Oh.
So $10,000 was the motion.
It's a punchline.
And even after the motion came through, defense attorney dug in. So we had to write a lengthy legal letter. This is a copy of the letter that got made to the new attorneys that came into the file, because the old ones got fired.
Oh.
So a very good firm from Westchester County came in and replaced Fogarty Duffy. That firm is called Amity Demers.
There's one for you.
And again, maybe you don't want to read the whole thing, but it's an example of the work that we put into these cases.
Cesar?
And after these letters went out, the case was scheduled for trial. The $10,000 offer went up to $500,000.
How much, say it again?
$500,000.
Okay.
$800 property damage. $500,000 PI settlement. This is why you send the case to me. Okay? Understood? Just because you're flat on your back doesn't mean if you take a lying down. No one fights harder for you than we do. If you know someone who has an injury case and they'd like to find out what to do next, have them call me.
Did they get the 500?
Yes, we got the $500,000.
Wow.
Yeah, we got it. I didn't bring a copy.